Thanks for joining us again for another episode of Consumer Trial Lawyer Academy. I'm Nick Wooten. I came up with this channel to help consumer trial lawyers be more comfortable with getting their cases ready for trial, being able to effectively present their cases at trial. I've been practicing law for 26 years, got hundreds of jury trials under my belt, thousands of bench trials. For some reason, I thought I was a trial lawyer when I started practicing law all those years ago, and for some reason, I still am. Over the course of the years, I've had some great successes, and I've also lost some trials. The purpose of these videos is to help you learn from all those experiences and shorten your learning curve if you haven't done this many trials and you don't have that much experience, to answer questions if you have doubts, to help you believe in yourself and your case, and to be confident that you're ready. Because at the end of the day, I am just one man. I can't help everybody try their case. I can't jump into every matter that's offered, and I can't answer all the questions that come up at the end of a CLE because there just isn't enough time. So this channel is to give you the benefits of whatever wisdom I can and whatever experience I have, and to hopefully help you miss some mistakes that I've made. And again, the goal is for you to be able to go stand on your own 2 feet in front of the jury and win, and be confident in each step of the way, so that you don't doubt yourself, doubt your preparation, and thereby give away your case through fear or doubt. So appreciate your time. It's always important. Anybody in this business that takes 15 or 20 minutes to watch one of these videos, I understand how precious those few minutes are. So I try not to waste any of your time. With that being said, what happens when you go to trial? You've done all the work, you've done all the preparations, you've been to pre-trial, you've spent the time between pre-trial and trial, fine-tuning everything, honing everything, knowing your evidence, knowing the presentation, knowing the witnesses, knowing what you got to ask, knowing what's got to be proven. What happens when you walk in the door? What happens when you get there for the first day of trial? Well, we're going to talk primarily about federal court and cases where you have a special setting. You're the only case on the docket. You're there for your trial, period. You're not there to see if your case is going to be reached. You're there to try your case. And everybody knows it. So everybody's been on the same playing field. And everybody's ready. And everybody's keyed up. And everything's full go. What happens? Well, you're going to go in that courtroom with your judge, who by now you should be very familiar with, and you would have had several interactions because of the pretrial planning process. They should have a good sense that you know your case in and out. You know the law. You're prepared to go to trial. Even if this is your first trial, you're ready. They should know that. Should be no doubt. And you're going to go through your preliminary things in the morning before they bring the jury panel in, just to make sure any remaining questions about how things are going to go forward or what the process is going to be are clear before we bring the jury panel in. And in federal court, they're going to bring the jury panel in, and sometimes they're going to have already had questionnaires filled out. In federal court, I always recommend use of a questionnaire because at the end of the day, you're going to get very limited voir dire. So you're going to need to have whatever information you can gather that gives you some sense of who the person is that you're dealing with. And it's much better to have it in writing right in front of you and be able to sort it out and get a sense of what you're up against as far as, what life experiences are involved in this group of people. In federal court, depending on the judge, depending on the size of the case, length of the case, you're going to get anywhere from 20 to 40, maybe 50 people max are going to come in on a panel for voir dire, and the judge is going to, decide how many to have on the jury. Most judges, it depends on your jurisdiction, but depending on the case, you could have anywhere from 6 to 12, and that's going to be your civil jury. And so You'll figure out these things during pretrial. Those are things that you'll want to ask. Those are things you're going to want to talk about with the judge's staff or the judge himself during your pretrial process. But you're going to want to know, how they do voir dire, how they strike the jury, what local customs are in place. If you're, a traveling litigator like myself, and you may be trying a case in the East Coast this week and the West Coast next month or anywhere in between, you need to know how those things are going to go down in that judge's courtroom and what their attitude is about each of those things. So those things, you have a sense of how it's going to go down. They bring you your jury questionnaires, and then they bring in the jury panel. And in federal court, most of the time, what they're going to do is they're going to call up 12 jurors. They're going to put them in the panel. And these jurors are going to be numbered on your list of jurors, and they'll call in the first 12. And, the first 12 will go through voir dire, where they will be asked the questions that the parties have agreed to by the judge normally. Whereas in state court, as a plaintiff, you would typically be asking all these preliminary questions. The judge is going to ask these questions. And then, once the judge has asked those questions, then the judge is going to typically give you the opportunity to ask specific follow-ups based off all the questions that were agreed by the parties. And you're going to be following up with things that that you've picked up on, either by body language, by answers, by whatever. And you're going to basically try to see if you can confirm whatever it is you suspect about that particular juror, with an eye towards determining always who can truly be fair in your case. In federal court, you're not going to really get to dig very deep on people because it typically is so limited, and there's such a strong presumption that anyone can be fair, and that's not always the scenario, as we all know, if you try cases. But you can get a strong sense of where people fall, usually between the questionnaire information, their body language, demeanor, attitude, responsiveness to questions from the court, things like that. That process can be smooth and quick, or sort of difficult and lengthy, depending on what types of responses you're getting from various jurors, etc. Keith Mitnick's book, Don't Eat the Bruises and Deeper Cuts, they have some great tips for, cutting to the chase with people and asking the kinds of questions that can reveal sort of inherent biases that people might not even recognize. It's a wonderful resource. I don't typically seek to use those questions at the outset of the voir dire process in federal court, and because the judge has these vanilla questions that they want to ask, and anything that's not vanilla is pretty much been removed from the equation for the judge to ask. I typically try to save those questions for follow-ups with people, and I'm really looking for the questions that are going to elicit some type of response that will open the door even further for me to inquire more. Again, jurors are not there because they want to be. Jurors are there because they have to be. They got a summons to come to court to potentially serve as a juror. And most of those people are deeply offended, but their time is being taken up. And if you are asking stupid questions and wasting their time, you're going to alienate everybody there. So make sure if you have questions to ask that they are direct and meaningful questions that are going to actually have utility in determining whether or not that person will be a good juror for you. As you're going through the process of the panel, the first 12, then you're going to get occasionally a response where it's clear that a person has a bias that affects their ability to serve on your particular case. For instance, you probably don't want a Wells Fargo branch manager in a case where you're suing Wells Fargo. And you likely don't want a debt collector on a case where you're suing a mortgage servicer. Those are obviously obvious scenarios, but there are many other things that come up that are said and done that make it clear that that particular possible juror isn't a good fit for your case. So again, you're always handling those people with the, kid gloves as gingerly and tenderly as possible, and simply just trying to confirm and understand that, how they feel about whatever the issue is. And then once you know they've expressed a bias, then you have to know your magic language to trigger a for-cause challenge, because, in federal court, each side gets 3 peremptories. So, you want to save those. That's like golden tickets. You don't want to use them unless you have to. And then, so you're looking for the challenges for cause, because those are free. If someone is clearly not a good fit because of experiences or beliefs, that's okay. It's wonderful. You should celebrate it whenever anyone's willing to speak up and talk about those things. And always ask if anyone else agrees with that particular juror's sentiment or feelings or experience or whatever it is, to always gather as many people as you can into that bunch, because the idea being the position that we are always taking with the potential jurors is, look, not everybody fits for every particular type of case. We all come to court with our own life experiences, and the process demands that we're fair and transparent about our beliefs and our thoughts and our biases about certain situations and certain types of claims, certain types of injuries. Some people are opposed to lawsuits entirely because they were sued in their own business or something of that nature. Some people have other issues, political beliefs. Some people don't believe in sitting in judgment. All kinds of things come up. It'd be no different than if you walked into a mall and picked 50 random people and just started talking to them about what they believe and think. You can imagine the number of variations you could get easily. That's exactly the way it is in the courtroom. And, you just have to take advantage of the very limited time you'll have in federal court and the very limited opportunity you'll have to speak directly to potential jurors, to elicit meaningful statements that will allow the door to be crept open a little further and continue to effectively open that door and confirm what you believe that juror's saying. And hopefully, if it works out that juror's not a particular fit for one reason or another, then you sort of can leave it in a way that you've all sort of come to an agreement that they probably wouldn't be the right type of juror for that case, rather than you're a bum, get out, because you can't set aside what you believe your whole life or your whole adult life, whatever. It's always about finding people who can just come into the case with an open mind. And so when you handle it that way, then you end up in a scenario where you don't look like an asshole for being the plaintiff and having to stand up and bring these issues up. You're constantly casting this as just trying to get 12 people who can start with an open mind and hear the evidence, be fair to both sides. Because if you think about it nowadays, there are plenty of people who couldn't be fair to a Wells Fargo or a Bank of America or someone like that because of some bad experience that they've had or their families had. So that sort of mode of addressing these issues that come up is fair to both sides. And I have, I've had jurors that said they couldn't be fair to a corporate defendant. We had that with Wells Fargo. We had, an investment, not an investment banker, but a business consultant who typically would be great for a corporate defendant. Say he watched a documentary about Wells Fargo and he basically thought they were trash. And, I basically got up and confirmed that he wasn't sure he could be fair, thought maybe he could set aside that opinion, but wasn't positive. And I thought that, Wells Fargo would then say, oh, he should be excused for cause. No, they were okay with that. And they left him on the panel, and he ended up being selected to the jury. And I think they were focused on the mindset that just because he was highly educated that he wouldn't smoke them. And I prefer to take the man at his word that he thought Wells Fargo was scum and wasn't going to be fair to him. Because I knew what the evidence was going to be, and he was already pissed off at him before he walked in the courtroom. By the time I was done, he was going to want to burn their whole world down. So I was happy to take a highly educated person who knows what zeros mean in a verdict against a huge corporate wrongdoer like that. So from my perspective, I don't ever prejudge things that we used to get told as young lawyers to prejudge. I don't prejudge, socioeconomic status. I don't prejudge education. I don't prejudge politics. I don't prejudge age, gender, any of those things. I don't assume that, someone who's fits into a particular category is going to agree with my client if they also fit into a particular category. They're young, they're old, whatever, they're male, they're female, they're Republican, Democrat. I don't care about those things. What I care about is trying to eliminate people who we know have biases that we know are not fair, and in my mind, not just to my own client, but to the other side. It's a little bit altruistic, but I feel like as a trial lawyer, I have a duty to make sure that we get 12 fair people. When a lot of lawyers would say, no, Nick, you have a duty to try to keep 12 people who hate the defendant if you can. I don't agree with that mindset, and I don't operate from that position. I operate from a position that if you can't be fair to either side, we need to go find some more people try until we get 12 that can be fair. So as you're knocking out people for whatever reason, all of them valid, none of them wrong. I mean, we're dealing with human beings. They bring their life experiences into the courtroom. They're not going to change who they are because of a trial. When they tell you who they are, believe them. Pretty simple advice. People a lot smarter than me said that. I was just smart enough to accept their teachings on it. But don't try to make someone something that they're not. And never be afraid to let go of a juror, when they say that they can't be fair. It's just don't worry about it. You're looking for fair because you know the strength of your evidence. If they come in there with an open mind, and by the time you're done, they're going to hate the defendants and they're going to want to burn them down. And they don't need to start, halfway to home. They can start in the batter's box. By the time you're done, they should be all the way home and back around the bases again and coming home for the second or third time. It should be batting around the lineup if you've done your case right. As you knock people out, you'll get down to some percentage of that first 12 people, 2, 3, 6, 8, whatever. When all the questions are done, anybody who survived is a juror. In most federal courts, they'll set them off to the side and they'll bring up 12 more until you get down to having however many selected, usually 12 if it's going to be a case that takes a few days. So that process just repeats in the groups until you get to 12 acceptable jurors or whatever your number is that the court decides they're using for your case. And in that scenario, you just really have to remember, again, you're looking for people who are fair, taking people at their word. You're always treating them gingerly, kindly, utmost respect and decorum. Never saying anything that could be considered harsh, mean, crude, rude, or in any way judgmental. I certainly don't want anybody judging me. I live in a glass house. Don't throw any rocks at me. I'm not going to throw any at you. So if you've done that, you do your job. That process can, It can take anywhere from an hour to a whole day to multiple days. I mean, I've only had one case where jury selection went more than a day. Very odd scenario, but in our types of cases, you can usually, say the first morning is going to be spent with that process. And then once you have that jury in the box, that's when the fun begins. That's when you get to really get going with the actual trial. And we'll start, our next video in the series will be about opening statements. We'll talk about that. Thank you again for your time. I hope that this information about the voir dire process is useful to you. God knows, first time I walked in the courtroom, I had no clue how it was going to go. But I didn't go first because I was doing a criminal trial, so I knew I could at least sit there and watch the defendants and get a sense of how, or the state, and get a sense of how voir dire is supposed to go down before I stood up. Thank God I've learned something since then. But yeah, it would have been awful helpful to have someone that could have shared some insight and experience with me about what the heck was actually going to happen, and not just fly by the seat of my pants. But anyway, glad to share with you. Hope that this is useful. If it is, like and subscribe, tell your friends, share it with your colleagues, kick it down to your law school professors, whatever you can do to help us create an audience and that we can share with. And we look forward to sharing more in the future. Catch us with the next video. We'll be talking about opening statements and what the philosophy is and how I do those things. So thank you again, and talk soon.